SJC-13572, Paul D. Craney et al. Versus Andrea J. Campbell, Attorney General et al.
Are we missing?
Are we missing somebody?
Pat Moore. Mr. Morris.
Oh, here he comes. Here he comes. Okay. Come on up. Thank you. Okay, Attorney McGinty.
Good morning, and may it please the court, Kevin McGinty, and with me Dan Goodrich for the plaintiff's appellants, and also present in the courtroom is plaintiff appellant Paul Craney. We ask this court to decertify petition number 2335, titled "An Act Giving Transportation Network Drivers the Option to Form a Union and Bargain." And we ask this for failure to satisfy the relatedness requirements of Article 48. Article 48 was designed to guard against abuses of the petition process, including packaging of inconsistent and unrelated provisions together in a misleading way. We think this happens here. This petition yokes together two unrelated means of regulating the transportation network drivers. On the one hand, collective bargaining. On the other hand, government control of wages, benefits, and working conditions.
But isn't the relatedness of those two pieces captured in the NLRA? I mean, isn't it, if they are independent contractors, then they can't collectively bargain unless there is a state supervision?
So I think Your Honor's question hits on what for us is frankly the main problem with this. What they want to do is illegal. So in order to make it legal, they can't do it. They promise collective bargaining, but ultimately what happens as a result of government control is not really collective bargaining. Because the object of collective bargaining, as would commonly be understood by the voters of the Commonwealth, is that workers get to control through a bargaining process the ability to...
But that seems to be an argument that you might make to the public about whether or not this is actually going to deliver on the promise of letting these drivers unionize and determine for themselves what benefits and rights they will have in this relationship.
I would say that's not the case, Your Honor, and the reason why is I think that if you look at this court's jurisprudence on what it means for provisions in a statute to be mutually dependent, one of the things that is necessary, we argue, and I think the cases bear this out, is that they support each other. I would point to Anderson, which
said that relatedness and mutual dependence are, two sides of the same coin.
Yes, and I think that the way this coin flip would come out is against it based on that, because I look at Anderson, and Anderson starts by parsing Article 48, by looking at the dictionary definition of the terms of mutuality and relatedness, and I think there in particular, very instructive language. It talks about dependence. It says dependence is when one is sustained by the other or relies on the other for support, and what we would argue is that a provision that, on the one hand, sets up, in theory, collective bargaining, although not really, and then on the other takes away the object of the fundamental object of collective bargaining is taken away by the second point. We would argue that they're not in any logical or legal sense dependent when you have that opposition between the two provisions.
How is it taken away?
The reason it's taken away is because collective bargaining is a process whereby workers organize and then they bargain, and the bargain connotes that they enter into an agreement that then controls what they do. Here, that doesn't happen because the statute in Section 6F says that all they have is a recommendation, and then what happens instead is that the Secretary of Labor, in the exercise of discretion, gets to decide whether to approve, deny, or modify those provisions.
Except it's using the same criteria that the arbitrator is supposed to use, if I read this correctly, right? And you're not challenging the provision that, you don't say that the provision requiring arbitration is unrelated.
No, not at all.
So how is it if the Secretary of Labor is using the identical provisions and standards that the arbitrators to use, that the Secretary of Labor's review is unrelated, but the arbitrator's is related?
So we are not arguing that the Secretary is exercising standardless discretion. There is standards set forth in the statute, as there typically are when there is a government power that's granted here. What we're saying is that the power to exercise that discretion and by doing so take away, override, negate the collectively bargained outcome. It basically transfers the power to make that decision from the workers to the government.
But that's the same power, to the extent it's being transferred, that's being transferred to an arbitrator.
But the arbitration is an ordinary incident of collective bargaining.
Yeah, but so I don't know that ordinary and unordinary is the same as related and unrelated.
Well, I think it is, Your Honor. Because one of the fundamental purposes of the relatedness doctrine, as elucidated in Craney and in a through line in the cases since then, is that provisions that are related at a high level of abstraction can be unrelated if they essentially group together provisions that are different from each other in a way that can be confusing and misleading to the voters. Here you have a statute that in the title makes no reference at all to that government power.
It doesn't make any reference to the arbitrator's power either, but you're not arguing that that makes it unrelated.
But that is an ordinary part of collective bargaining, whereas government control over that process is not.
But this isn't ordinary. This is, I mean, you were here for the previous cases. The rideshare companies are trying to change the relationship. And they're saying they're neither employees nor, they're independent contractors. And this seems to be, what's good for the goose is good for the gander. You've got an ability to set up a collective bargaining system for these type of people. But if they're private sector employees, the NLRA precludes it. If they're public sector employees, they should be in the state system. This is creating a new system, and in order for that new system to be legal, it has to satisfy antitrust provisions. So why isn't that related and mutually dependent? It's mutually dependent as a matter of law. I just don't see why this is a problem, particularly if the other things are all permissible.
Well, I think where I would differ with that analysis, Your Honor, is that what is being set up essentially is something that in a way that's not obvious from the title, it's not obvious from the summary, it's not obvious from the first 15 pages of the
It's
petition.
something
It's something
new.
different.
Something new. The rideshare companies believe in a new relationship. This new relationship, we're going to create, the people respond to this, like, okay, you may win, but this new relationship can have a collective bargaining component. And that's all that they're saying, that in order for that to be legal, they have to have this government oversight or it's illegal.
I think the problem is that what is offered as collective bargaining is in I think, two
Well, it isn't
significant respects
traditional collective bargaining, but it's a version of collective bargaining, the same way the rideshare companies are creating a new employment category.
But I think the fact that it's different matters.
Why?
And it matters from a perspective of what the ordinary voter, as we heard in the last argument, would understand about what this question means. They would ordinarily understand that collective bargaining means what it typically means. If they're in a union, they would understand it means that we get together and negotiate a contract, and that controls, and the government can't Bigfoot our decision. They would understand that the ability to participate in the union applies to all workers. Here you wouldn't know without reading 15 pages, actually more, 19 pages into the petition, that actually not all workers can participate. Only half of them can actually decide whether to do this, and then a minority of them can control the decision to organize.
It's clearly something new, but is it like the marijuana? Is it creating a new world that's unified? They're saying, okay, I'm voting on these other initiatives to say I'm not an employee, but I want some power, and this is the counterbalance to that.
So I think that the Hensley case, the marijuana case, is actually an interesting counterexample, because there was actually the same problem in Hensley that the petitioners here confronted, which is that there was a federal prohibition, still is, that essentially marijuana is a federally scheduled substance. Perhaps it will be changed soon by the Biden administration, but at the time it was illegal. And essentially the petition was able to put forward this unified, consistent program of regulation and legalization.
Isn't that sort of like what's going on here? They're doing a slalom course between what's legal and what's not.
The problem is that this slalom course takes them into the slalom pole or into the barrier, because that as I said at the beginning, in order to do what they want to do, they can't do it. It really ends up not being collective bargaining.
California, why aren't the grape grower, the grape workers or the farm workers example very comparable to this? That the farm workers would not be traditional employees because they move from place to place, but they legalized a collective bargaining structure for them in California because they were powerless and different.
Well, I take your example, Your Honor, and I think if we look at the amicus brief here from the labor law professors, they're of the opinion that it isn't necessary to do this two-step process that gives a watered-down, not really collective bargaining thing that summons into effect government control. They basically say, in their reading of the labor laws, the state could just do it. That the petition could just say, we hereby declare that rideshare drivers, that transportation network drivers can organize collectively and bargain, and they say it's legal to do so. Candidly, that's a stronger basis to go forward than you would have had in
But then they can,
Hensley.
they're taking a big risk that it's going to be preempted by the NLRA or the antitrust laws, aren't they?
Well, it's a choice they made, but the problem is that by trying to avoid that problem, they created a statute that's at war with itself, that's incoherent.
Counsel, can I ask you a question? Because I still struggled in reading your briefs to find, when does this actually, the exercise of discretion, ever not have this circular effect? Because they're out of NLRB, and the only way to avoid antitrust issues is to have some state supervision. But to read your brief, any state supervision would nullify the underlying provision. So is there some continuum you could point us to and say, how much oversight is enough to make this all lawful? Because according to what I've read, at least in your brief, this would never be lawful. This would never be legal.
I think the challenge you have is that you can't, at least the way they've structured it, have real. You don't really have collective bargaining, so you can't. They nullify themselves essentially. They render the collective bargaining provision of it.
Well, that's what I'm getting at. So I'm asking you a specific answer. So they bargain with the ride shares, and they say, here's the suite of things that we think we can all agree to. They send it off, and they say, well, you know, these couple of things really bother us, so we want you to either modify this back to the drawing board, or here's a potential workaround from the state's view. What level of interaction is lawful in your world? Because it seemed to suggest that anything other than a rubber stamp from the state wouldn't suffice.
I think anything other but a rubber stamp makes it not collective bargaining, which is why we say they're inconsistent.
So that's what I'm asking the same question. Whenever would you but when would this ever be lawful? What Article 48 question could they propose that in your world would never be okay?
We think there's three ways that this could be done. One is to be very straightforward about it and have the mirror image of the question that this court just heard, which is, we hereby declare these workers to be employees. And when they're employees, then they would fall within the ambit of the National Labor Relations Act, and they could then organize collectively. It would be very simple, issue straightforward.
But we don't control whether the feds think that's correct or not. We can say that, and the feds can say, they got their own tests for whether you're an employee, and they're not prone to being pushed around by us.
Well, that's potential objection to the second basis, which I've already discussed with Your Honor, which is they could just be like Hensley and say, we're just going to legalize this, and they're on stronger grounds in Hensley, because if you believe the amicus brief, there are arguments that they could advance that would say that would be a legal basis on which to organize. And then the third thing is, you get rid of the performative organizing process that really just the main purpose of which is to summon into effect this government authority, and just say, declare the Secretary of Labor, through whatever agency we're going to establish, will establish the terms and conditions for these workers using exactly the same criteria that are set forth in Section 6. So there's three different ways you could do that avoids this complicated and incoherent meshing together of unrelated provisions.
I just want to understand, your argument about relatedness hinges only on section 6F?
Yes, that is our.
Only 6F.
I would say that's on 6F, yes. Although I would say that in understanding the Article 48 issue overall, I do think it's necessary to consider as well the buried provisions that dilute worker participation, which also would be contrary to what individuals might understand to be the case for how collective bargaining works. I've hit the end of my time. Unless the court has any further questions, we'll rest on our papers.
Okay, thank you.
Thank you.
Okay, Attorney Moore.
Good morning, Your Honors. May it please the Court, my name is Patrick Moore on behalf of the Attorney General and the Secretary. I appreciate the Court's indulgence for my embarrassing lateness in returning from the break. The proposal here to allow rideshare drivers to unionize and collectively bargain while actively supervised by the Commonwealth is consistent with the related subjects requirement. As a general matter, a policy proposal and state oversight of that policy is a common feature of ballot initiatives. This court has seen it in Clark, where the Division of Insurance oversaw medical loss ratio in dental insurance plans. It has seen it in Hensley, where a Cannabis Control Commission was created to oversee recreational marijuana. Voters have seen it in initiatives that have gone to the ballot without passing through this court. Right to repair is enforced by the Attorney General's office. Medical aid in dying, which did not pass, but was to be, had it passed, enforced by the Department of Public Health. This petition is even more related than those, because here, the state oversight that has been proposed furthers the policy proposal. Here, the policy proposal is to provide for collective action by drivers, so that drivers may use that collective action to improve the terms and conditions of their work. Here, state action furthers that because it allows the proposal to be harmonized by federal law. Challenger's argument, as I understand it, is that state supervision is inconsistent with collective bargaining because collective bargaining gives workers power, and state supervision takes that power and gives it to the state.
Have we ever said that mutual dependence is, I mean, your argument is these things which seem, they're legally compelled. Have we ever said that mutual dependence is satisfied by legal dependence? I just don't know the answer to that.
Not expressly so, Your Honor, although a petition that navigates existing law is a common feature of the initiative process. That's true in practice, it's true in the case law, and it's certainly true in the history of the Constitutional Convention. So beginning with case law, we see in Dunn, for example, Dunn dealt with farm animal treatment and had a provision in it to avoid preemption by the Federal Meat Inspection Act. That provision wasn't even challenged. Obviously, Hensley inherited a federal legal regime through which it tried to navigate by not conflicting too much with federal law, and a state legal regime where there was medicinal marijuana. And it navigated that by basically allowing the medicinal marijuana dispensaries to wrap into the recreational marijuana system that was created in that case. In Abdow, the question the petition sought to pose to voters was, should expanded gaming be repealed? And that begged the question of what would remain. And the petition dealt with existing law in that setting as well. But here the purpose is to facilitate collective action by drivers. The state oversight is in furtherance of that purpose. It is meant to give effect to the petition. My brother postulated a handful of different other options here. First, of course,
Before you go to his, can I ask, if theirs doesn't pass, say we approve theirs and the other 5 of them, or which will be 1 eventually, which makes the they're not employees, right? They're going to be independent contractors. If that doesn't pass, there's an undecided issue whether these people are employees or not. How does yours coexist if that doesn't pass, is there a legality issue with this, and do we just put that aside? How does that, because there's a case that's coming out in July or August, right, deciding whether these people are employees or not, right?
Correct. So
I'm just trying to get a sense of how all this works together.
A multifaceted question, Your Honor, and it deals with the interplay of the various different employment tests and also federal law. So let's begin with the federal law sort of superstructure, because we don't have the ability to change that.
Right.
As Your Honor noted, antitrust law, generally speaking, prohibits conspiracies to restrain trade. There was a question for a period of time in the early 1900s whether labor activity was such a conspiracy, and federal law changed through the Clayton Act, Norris LaGuardia Act, and the National Labor Relations Act to create a labor exception to antitrust law. At least as classically interpreted, that labor exception is limited to employees, but not employees as defined under state law, employees defined under federal law, under the NLRA, which is a 10-part multi-factor test that is quite different from the ABC test here in state law. So at issue before the Superior Court now in an enforcement action brought by the Attorney General is whether the drivers are subject to the Commonwealth's wage and hour law. And that is answered by the ABC test. The answer to that question does not resolve the federal labor issue. And it is not at all clear that the NLRB now or ever will recognize drivers as employees. So this petition, as I understand it, was drafted to both work in the event that the industry-supported petitions are passed, or if they do not pass. And it was meant to work regardless of the outcome of the current enforcement action. And it does, because it is seeking
Just to be more precise, just one question for me. So if the finding under this case that's pending in Superior Court, which obviously hasn't been appealed, everything else, is that they're employees, how would this coexist? Because if they're employees, I guess because of the conflict with federal law. Okay, I got you. Okay.
So they would need to be employees as defined by the National Labor Relations Act to have the ability to unionize and collectively bargain under that act. The National Labor Relations Board has not held that they are employees. It is a different test. It is a multi-factor test where no one factor is determinative, and there are factors that are perhaps more favorable to the companies than are the ABC factors in state law, and there is no presumption. Of course, there's a presumption in state law under the ABC test that a worker is an employee unless each factor is shown. So a lot of ink has been spilled on the related subjects requirement by this court. I know the court has spent a lot of time today already on that, and will again return to the subject on Wednesday. I would suggest to the court that the analysis is actually relatively straightforward. What is the policy being proposed to voters? Is it too abstract, or is it something concrete that they may understand and answer? And then looking at each provision, does the provision A, further the policy, or B, recognize and address a consequence of the policy? The petition here, and particularly as Justice Wolhojan's question pointed out, 6F is what is being challenged here. So does that further the policy? Well, yes, it helps it navigate federal law such that collective bargaining can be in effect. Now, can it be in effect in full, as the way the challengers have suggested? No, but through no fault of state law, that's a function of federal law. The petitioners here are entitled to take the world as they find it. They are not forced to operate in a world of pure logic. Unfortunately, all of our laws don't necessarily exist in such a world, and they're entitled to navigate that. That's what this provision does. It also addresses and mitigates a consequence of the unionization structure here. It is possible. This is sectoral bargaining. These are all of the drivers working for rideshare companies who are negotiating with the companies on compensation terms of work. There is a world in which the companies and the drivers effectively collude to keep other players out of the market. The state action here addresses and mitigates that consequence. If I may turn just briefly to the constitutional history here, the Convention of 1917-1918, which adopted the initiative petition, was doing so largely through the advocacy. If you read the debates, the members arguing for the initiative are doing so for worker treatment purposes. Labor was a big part of it, but not entirely, asking that workers need to be treated better, and it would have been no surprise to those proponents of the initiative that federal law would need to be navigated in proposed initiatives to do that. Let us keep in mind this was
You're not suggesting that a bill that passed that treated workers less well would not pass muster, right?
No, of course not. The framers were very well aware that people supporting their policy ideas and people opposing their policy ideas would use the initiative process, and they put in several safeguards, of which relatedness is the most prominent, to address that. But this was the Lochner era. The fact that you would have to navigate federal legal issues in a petition would have been no surprise to the framers of Article 48, and in fact is addressed throughout the debates on Article 48. I know this court has perhaps more ballot initiative matters before it, so I see that my time is running down, though not fully up. I'm happy to address any further questions. Otherwise, I would ask the court to affirm the decision to certify by the Attorney General, and we otherwise rest on our submission.